Sebentar ya, Yang Amat Arif, Yang Arif. Untuk Datuk Abu Bakar bin Jaiz. Baik. Dengan izin Yang Amat Arif, Yang Arif, Yang Arif. Persidangan Mahkamah Persekutuan Malaysia di Putrajaya pada 8 November 2023 Rabu dijalankan secara sidang video. Panel pada hari ini dipengerusikan oleh Yang Amat Arif, Tan Sri Dato' Amar Abang Iskandar bin Abang Hashim, Presiden Mahkamah Rayuan, dan ahli-ahli panel terdiri daripada Yang Arif Dato' Abu Bakar bin Jaiz dan Yang Arif Dato' Abdul Karim bin Abdul Jalil, Hakim-Hakim Mahkamah Persekutuan. Kes permohonan sivil dipanggil nombor 20 dalam senarai. Permohonan kebenaran merayu nombor 20 dalam senarai 08F54012-2022W. Pemohon Hao Chi Hong, responden Chung Ju Tian dan 3 lagi.
Good morning, my lord.
Yeah.
Stephen Howe, together with me, Daryl Chang, for the applicant, and my learned friend, Raghunath Kesavan, and Sherin Tang for the respondent.
Yeah.
Hey, Arif.
Yang,
Yes.
my lord, today is fixed for this hearing of this notice also for leave to appeal. Before we proceed, Yang Arif, or Yang Amat Arif, we have two issues to brief the panel. The first issue is the fact that we just actually found out that Yang Amat Arif was presiding over a matter, an appeal matter, relating to an appeal by the complainant in this disciplinary inquiry to the Court of Appeal on the issue of intervener. An application to intervene by the intervener, which is the complainant, and that the hearing of the appeal was conducted before Yang Amat Arif, one of the panel members, and as such, we are of the opinion that it may seem that Yang Amat Arif may be biased in this matter. What happened is that in that application, it was an application by the complainant to apply as an intervener. In this hearing of the leave is also an application by the complainant for disclosure of documents. So the complainant have applied for disclosure of documents in the disciplinary committee. And the appeal and the leave application is arising from that application. So it's arising from same complainant, the application. One is on intervener, one is on production of documents. So we need to inform this to Yang Amat Arif in order for Yang Amat Arif to consider whether there is whether it was seen to be of bias. That's one, Yang Arif.
Yeah, second one.
The second one, Yang Amat Arif, is the fact that I'm still on MC, a medical certificate, because I had a fall about a week ago, And in the fall, I fractured my foot, my right foot, and injured my back. I've been given a 2 weeks MC, and it was supposed to expire next Monday. I've written for adjournment, but it was rejected by the panel. I would like to reiterate and to reapply for an adjournment. Reason because also the fact that for the last 10 days or a week, I have been labored by this tremendous pain. Although I'm on a very strong painkiller, but it was tremendous. And it actually affected my preparation for the trial, for this hearing today. It has seriously affected me. And even today, after the painkiller, I am also in tremendous pain now. I do not know why, because it's supposed to have reduced the pain. But up to today, I'm still having that tremendous pain. In fact, I've made an appointment to see a specialist for my back tomorrow. I am applying for the good grace of this panel that to allow my adjournment because of the fact that I'm really suffering pain. And now I'm at home doing this Zoom from my house, of which is not equipped for that. And I hope the panel will allow the adjournment for me to recover from this. It can be a very short adjournment. I'll be much grateful to the panel. Arif. I'm Arif.
Right, thank you. Thank you.
Thank you.
Yes, yeah.
Yang Arif. Application yang the application stated by my learned friend relates to an intervener application, and in fact, there's no issue of bias because the Court of Appeal had actually ruled in favor of the applicant here. In fact, if anyone would be aggrieved or would want to seek for recusal of any member of the panel, it should be the respondent. It is an intervener application. It is somewhat related, but the complainant in the intervener application wanted to intervene in the disciplinary appeal. The High Court refused and the Court of Appeal refused. So the hearing in the High Court in relation to the disciplinary proceeding proceeded without the complainant. It was the respondents who attended to the hearing. It's the respondents who filed the notice of appeal from the High Court decision. And it is the respondents before your lordships today in relation to the leave application. As any interlocutory application, the intervener application was an interlocutory application. It could be heard by any judge, and there is no automatic need for recusal for the main matter to be heard by the same panel or the same judge. It would be similar to an Order 14 application, for instance, before the High Court. And if it's dismissed, the full hearing goes before the same judge. So the matter that came before Yang Ahmad Arif was an interlocutory application in relation to an intervener.
Yes.
It wasn't on the merits of the matter before your lordships today. That's on the issue of recusal of Yang Ahmad Arif.
Yes, yes.
On the second matter, Yang Arif, I do sympathize with the learned applicant in relation to what he's stating. Just for the record, Yang Arif, I have to object, and the reasons are as follows. This is the third time. We did not object on the first and second time the matter came up for hearing, for the leave application.
The most important thing is the ground of the application.
Yes, Yang Arif.
Well, are you saying that the ground for today application is not true or whatever?
It's my lord, it is not
That's important.
yes, I agree. My
Yeah.
lord,
The ground.
the issues are this. The appellant is appearing in person today. Applicant. In the High Court and at the Court of Appeal, he was represented by counsel. And in fact, the second application for adjournment was on the basis that his counsel was not well, Mr. N. Nathan. The first was also because Mr. Nathan was not well. So, and my lord, what we're saying is that this is a leave application. Submissions have been put in. It is not a complicated matter which would require a full hearing over 3 or 4 days. And as it is the third time the matter has been adjourned, ample time would, there are other counsels available within the firm. Mr. Nathan is still with the firm. So I don't know why he's not here today. But for that reasons, my instructions are that for the respondents, the matter involves a disciplinary body proceeding, a matter of public interest, and we have been kind and we have been lenient in terms of not objecting for the previous 2 applications for adjournment, and therefore, Ya Ma'arif, Ya Arif, we object to the adjournment, and we urge and humbly pray that the application proceed today. Much obliged.
Thank you. Thank you, Dato'.
Yes,
Yes,
if I could interject, but if I could address this to the applicant, wouldn't I be right to say that you are not estopped in asking for the remedy under 103 of the LPA? You can still resort to that and not pursue this leave application. And for all you know, because of what you can still pursue, the documents might not have to be revealed. Am I right to say that you are not estopped to put up an application so that the document is not revealed, at least for the time being? Would I be right in saying so, Mr. Raghunath?
Sorry.
Yeah. I want to. Can I listen to Mr. Raghunath first?
Oh, I see.
Would I be right that the applicant is not estopped?
My lord, yes. One of the objections we have is that the internal remedies has to be exhausted before the matter comes to court. Of course, there are exceptions to that when there is access or no jurisdiction by the disciplinary committee, Kivati's case and the Jagdish Singh matter. But in this matter, the Court of Appeal has ruled that there was no excess of jurisdiction, abuse of jurisdiction by the disciplinary committee. It is open to
We are going into the merit now.
No, just to explain.
Because if I can recall correctly, they say that they have made application for extension of time, but that application for extension of time was rejected to file the written objection. They have made the application, so how could they now apply for to proceed under that provision if they already applied and they stopped and not given?
Yeah, the provisions are clear. 103 EA, 103 Section 103 of the Act. You must exhaust all internal remedies. So the option is available to the respondent. He can apply to raise his objections. He did not do so in time. And subsequently, the matter is still pending in the disciplinary committee. It's not a matter as if that.
So do you agree that he can still apply?
Yes, he can still apply.
But I thought what I read in his submission saying that he already applied for extension of time to file the written objection beyond 14 days, but the committee rejected his application.
My lord, the committee has not decided on the complaint at all.
No. The application for written objection must be filed within 14 days, right? Not?
Yes.
And he has already passed that 14 days, and he applied for extension of time to put in the written objection application that was rejected.
Yes, my lord.
So he cannot raise this written objection anymore. He cannot apply for this procedure anymore, you know. Unless
not
you are agreeable
stopped.
that he can apply now.
My lord, he is not stopped from proceeding with the hearing. The disciplinary board has not made a decision on the merits. They have not made a decision on the merits. This is a purely an investigation stage. An order was asked to be made, and this was all ventilated at the High Court and Court of Appeal on the merits of the application.
We're going into the merit now. Okay.
Yeah, I think we're trading towards that. And I think there's a danger that we might wait even further in. All right. I think the point's noted. But I just would like to ask Dr. Kesavan, in relation to the application which was made for the discovery of the document, who made that application? Is it the complainant or the DC, sir?
The DC made the order.
No, made the order to produce the documents. Huh?
Yes.
That's it. Okay. All right. Just Stephen?
Yes.
Shall reply, if any?
So, yes. My lord, the issue on the biasness, my learned friend has raised the issue of the fact that there was no bias. Reason because the order of the previous Court of Appeal was in favor of us, i.e. the complainant was disallowed to intervene. So the complainant was disallowed to intervene. Yes, it was in our favor. All the parties attended the hearing. And in fact, that is the very problem for us, because the fact that it was disallowed, there may be likelihood that the Yang Ahmad Arif will be consider them as a party that was not here, and as such allow them the discovery of the documents. So that's what I'm saying. It's just a reasonably seem to be a bias. It's not that I'm alleging any biasness. So therefore, the fact that it was allowed or disallowed is actually immaterial. The biasness, because of the fact that the whole facts of this case was reviewed during that time by the complainant. And what is important is also this. In this very leave application, there was one issue. The issue of the affidavit of the complainant used during that intervener application was also used here in this discovery application. That same affidavit was used here. And that same affidavit was adopted wholly by the respondent. The respondent, being the committee, adopted the affidavit produced by the complainant. I mean, that is definitely a conflict. So, so we are also challenging that. We are saying that that should not be used, cannot be used by Order 32 Rule 13. But anyway, so we are saying that there is a possibility of biasness.
All right.
Now, the other thing on the fact that on the intervener, on the question that whether we were stopped, as pointed out by Yama and my lords, it is correct that 103EA1 has been exhausted. An application for extension of time was filed, and it was disallowed. So everything has been exhausted. Obviously, my learned friend says parties should proceed with the proceedings. But this is at the stage of the discovery. This is what we call a legal professional privilege documents. And these documents cannot be allowed to be reviewed. If it's reviewed now, and we wait until the hearing of the DB and DC over, then only we appeal, will be too late. Everything will be out already. So as such, and also finally, I want to reiterate the fact that the conditions I've suffered, it's very true. Number two, Mr. N. Nathan, the reason why N. Nathan was not here was very broad because he was the counsel for me earlier, up to May this year, when he fell sick and his medical condition does not allow him to handle any more cases. And that is when June or July onwards, I took over the matter. And I'm doing it myself. Because N. Nathan, it's not in a position medically to handle any matters. So when I took over the matter, the hearing was adjourned once, reason because I was sick. I was having a very bad throat problem. And we don't choose when we are sick, my lords. I really have to apologize to my lord that I'm in this condition, but I'm not, I mean, we don't choose when to have an accident. So, my lord, and this happened like 10 days ago.
Okay, and Stephen, I think the reason why the panel did not accede to your request for matter to be adjourned has been that the MC which you produced to the court did not reveal the nature of your illness. You know, so it becomes difficult for us, right, to decide either way.
Yes.
And in such a case, we thought that it would not be proper to give you the benefit of doubt.
Yes.
I think we need to have a specific finding from the doctor, who had treated you, and come up with his conclusion as what is the kind of ailment which you are suffering from. So as of now, we don't have that, the benefit of the medical opinion.
I don't have that. Yes, very well. I don't have that, my lord.
Okay, so I think we will stand down for a while and come back with our ruling. All right, thank you.
Dengan izin Yang Amat Arif, Yang Arif, kes dipanggil semula.
Yeah.
My lords, parties as before, my lord.
Yes. Okay. This is our rulings. As regards the application for my recusal, I have no good and valid reason, but I see no good and valid reason for me to recuse myself and to accede to the request made by Mr. Stephen Ho for me to be recused. Yeah, I agree with Mr. Dato' Kesavan that the application for intervention, which appeal was set before us, before myself was on the panel, was an interlocutory matter and did not concern the merits of this matter. As such, I see no merits in the application by Mr. Stephen Ho for me to recuse. I will remain on this panel, to hear this matter. As regards the application for adjournment, we will give Mr. Stephen Ho a short adjournment as requested, right? And we understand that the 27th of November is a date which is convenient for all parties to reconvene and to hear this matter. Yeah, this matter is a 2022 matter, and we believe that it is in the interest of all parties that this matter be decided upon one way or the other. Okay. So
Much
see you on
obliged.
27th of November.
Much obliged,
Much
Yang
obliged.
Arif.
Thank you.
Permohonan kebenaran merayu nombor 21 dalam senarai 08F 3202-2023C, pemohon Jonex Malaysia Sdn Bhd, responden Venture SKL Sdn Bhd.
Yang Ahmad Arif, Yang Arif. S.
Yep.
Ravichandran, together with Kanesh Rao for the applicant, pemohon, and my learned friends Dato R.K. Nathan, Vinod Kamalanathan, and Anis Amira appear for the respondent.
Yes.
Thank you, my lords.
Benar Yang Arif.
My lord, today's leave application, there are 4 questions we have posed that can be
Yes.
found at page 1 of enclosure 13. If I may share screen with my lords. It's a revised questions, my lords.
Is submission.
It's also in the submissions, my lord. Enclosure 30 is our submission. Revised questions. My lord, there are 2 issues in these questions. The first 3 questions involves interpretation of contract documents by the court when there's no ambiguity. And the 4th question is whether an appellate court is empowered to order an assessment of damages when there are no order for split trial on liability and quantum of damages at the trial court. Those are 2 issues, my lord.
Yeah.
Can I take the first issue, my lord? Questions 1 to 3. My lord, in this case, an agreement was entered on the 26th of February 2016 between the appellant and the respondent, whereby the respondent was appointed as an exclusive subcontractor to carry out mining on the mining land. This agreement can be found at enclosure 5, my lord. My lord, nothing much turns on that agreement, so I will not bother my lords with that agreement. My lord, subsequently, the applicants and the respondents have held meetings. This is crucial, my lord. 19th of May 2016 and 31st May 2016. These are minutes of meeting, and this is found at page PDF 7 to 10. I intend to, can I share a screen with my lord on these 2 documents?
Yeah.
My lords, during the meeting, the applicant and the respondent mutually agreed that the agreement dated 26 February 2016 be treated no longer valid and will be void. My lord can see that on the bullet, if I may highlight that. Bullet number 1, my lord. Agreement dated 26 February, no longer valid and will be void. And then there are other subsequent, which I'll refer to later.
And will
Now
be void, huh? Will be void.
Yes, will be void. No longer valid and will be void.
Yeah.
I go on to the second minutes, my lord, which is on the 31st of May 2016. Bullet 2, my lord. Bullet 2. Agreement dated 26 February 2016. No longer valid and will be void. Again, they repeat that. Of course, there are other things. I'll come to that later. My lords, both these minutes were signed and acknowledged by the respondent. There's no dispute. My lord, the Court of Appeal, we submitted the Court of Appeal. If you quickly look at the grounds of appeal, that's found at enclosure 21. I share screen, my lords. No, grounds. No. Sorry, yes. Paragraph 29. Sorry, 28, my lords, 28. If I may read, my we have consequently reviewed the minutes of the meeting in entirety and noted there were discussions recorded in both meetings as per the first item in the agenda on the parties' expressed desire to treat the agreement no longer valid and will be void, but there was nothing concluded expressly that the agreement is henceforth null and void. My lords will observe only the word will be void is highlighted in the grounds of judgment, not the entire sentence, no longer valid and will be void. So what we are saying is the Court of Appeal was selective, has read the minutes selectively, the 2 minutes I referred to earlier, and isolated the words will be void. They ignored the word no longer valid, although it's there, but it's not highlighted. My lord, the Court of Appeal also mistakenly treated the pre-contractual negotiations as per the minutes as subsisting and contract between the parties. If I go back to the 2 minutes, my lords, which I have referred to earlier.
Mr. Ravi, if I could interject.
Yes.
Can you show your first question of law that you propose?
Yes.
Because if I remember correctly, for your first question of law, there is no reference to any documents, including minutes. Would I be right in saying so? So can you show your first question of law?
First question is, whether the contract is allowed to interpret documents, evidence, documentary evidence objectively when a literal interpretation of the same does not cast any doubts as to the party's intention.
And that is revised question of law. When did you revise it?
It's submission stage, my lord.
Can you do that? Can you revise your question of law at submission stage?
Can, my lord. I think Terengganu Forest allows that.
So you are saying because of Terengganu Forest, you are using it to revise at the stage of the submission?
Yes, my lord. In fact, if I'm not mistaken, Terengganu Forest even allows during the hearing proper, a substantial hearing, the court.
Okay, no one. We will listen to Dato' Kamal Nathan later. You can proceed.
Yes. So if I may continue. So going back to the notes, the minutes, my lords. This minutes of the 2 minutes which I referred to earlier. My lord, if as I said earlier, we have to look at the minutes in bullet 1 we have referred to, and then no. Bullet 2 onwards, it reads no longer bullet 2 no longer valid due to lots of dispute and no proper signatories from both parties. Mr. Lee will be major shareholder effective 23rd May 2016. Transition period in process is a major shareholder for Ventures SKL Sdn Bhd. New agreement will be drafted by Mr. Siva Yonex Sdn Bhd. Conclusion. New agreement needed to be drafted as soonest while Mr. Lee is away to Taiwan from 20th May 2016 and 30th May 2016. Tentatively meeting 31st May 2016, Kuantan, and exact time and venue will be confirmed in written via another email, SMS, WhatsApp, WeChat. My lord, can I then the discussion the bottom of that minutes, we have the discussions, various discussions were taking place. And then I go on to the next minutes, my lord, which was on the 31st. Again, bullet 1 reads, new SSM or company profile from VSKL. Agreement dated 26 May 2016 no longer valid and will be void. New agreement will be done after SSM received from VSKL. As major shareholder, signatures from Mr. Lee Hua Xiong is required in the new agreement. Conclusion, and then at the bottom, discussion. My lord, this is where the Court of Appeal ruled that because of this minutes, they felt that the Court of Appeal held that the agreement is still valid because there were negotiations going on. My lord, what we are saying is this. Clearly from these contemporaneous documents, the 2 minutes, it is plain that the parties were negotiating terms for a new intended agreement, my lord. If the agreement was enforced, the parties would have said, we will revise or vary the existing contract. They did not do that. They have clearly said that it is no longer valid and null and void. That's why they've used the word consciously, no longer valid and will be void. My lord, may I refer to the grounds of appeal of the Court of Appeal? What's findings, my lord, from paragraph 26 onwards, my lords? My lord, paragraph 27, according to the respondent, the parties mutually agreed at the meeting that the agreement was treated as null and void and a new agreement would be entered. However, as far as the applicant is concerned, the agreement would continue in force unless and until the new agreement is executed. 28, my lord. We have consequently reviewed the minutes of the meeting in entirety and noted there were discussions recorded in both meetings as per the first item in the agenda, and the parties expressed desire to treat the agreement no longer valid and will be void, but there was nothing concluded expressly that the agreement is henceforth null and void. We submit that it's so clear, my lord. We don't need anything more because the words are very clear, no longer valid and will be void. But we say that the Court of Appeal went wrong there to say that expressly the agreement is henceforth null and void. There's nothing concluded.
Yeah.
29, my lord. Further, we noted that there were also expressed discussion and conclusion recorded in the meeting held on 19th, that the new agreement will be drafted by Mr. Siva of the respondent and new agreement will be drafted out as soon, respectively. At subsequent meeting on 31st May, the express discussion and conclusion recorded were that the new agreement will be done after SSM received by VSKL and new SSM documents are required with attached Mr. Lee Hua Xiong as director and major shareholder, respectively. 30, my lord. I don't see. No. Sorry, my lord. It's taking some time. My lord, sir, paragraph 30.
Yeah.
30. Sorry, my lord. Opposite that too, we also noted that there were discussions and conclusions on plan/project and cash flow in the meeting held on 19th May. as per items 2 to 3 in the agenda, as well as on discussions and conclusions on planned project, deposit payment and quantity changes in contract in the subsequent meeting held on 31st May as per item 2. This is where it's crucial, my lord, paragraph 31. Consequently, we objectively find from the meetings that the presumed intent of the parties is that the agreement still subsisted unless and until replaced by the new agreement. Simply put, it was plain that the parties did not mutually treat the agreement as already null and void. We are persuaded by the wordings as adopted in the minutes of the meeting, highlighted above, as well as the conduct of the parties in having discussed and settled the meeting 2 on various items which are consistent with the ongoing performance of the agreement. This is where we say that the Court of Appeal fell foul. They were negotiating for intended future agreement, where they concluded that the existing agreement, 26 February, is null and void and of no effect. My lords, also it's an evidence, but the respondents' conduct of abandoning the mining land in 2016 and leaving behind some machinery and plant also confirms that the state of the old agreement, the 26th February agreement, is no longer valid. My lord, also we have to look at other documents, my lord. Numerous notices from the applicant and its former solicitors, Vendagan, had refused to machinery plant from 2016 to March 2018, spanning over 2 years. My lord, I like to just quickly refer to these letters, my lord, so that we have about 7 or 8 letters. The first letter will be in enclosure 5. My first letter is dated 2nd February 2016. PDF will be 150 to 155. No. This is Sean's letter.
Yeah.
Another letter. 2nd September, my lord. No. Sorry, my lord. Again, we are having some technical problems. Letter dated 2nd September 2016 from Vendagan. Second. Where's the letter here in the heading? Yes, 2nd February 2016, my lord. May I refer to the first paragraph of that letter? We refer to the above mentioned, wherein our client Yonex Sandhya Bharat have informed us as follows. You are the solicitor for Venture VSKL. They wrote to their lawyers. Our client and your client have had a series of discussions and meetings and have agreed inter alia that the earlier agreement between the parties is treated as no longer valid and void, and parties now wish to negotiate a new agreement. What is the reply to this will be on the next letter, my lord. Their lawyers reply on the 5th of February. They say, we refer to your letter of 2nd February. We are currently not instructed to act as Venture SKL in respect of your contention. To this, Vendagan replies on the 7th, my lord. We refer to the above caption matter, wherein we have been engaged by Geonex to instruct as follows. Parties had met, discussed, and agreed on 19th May 2016 and 31st May 2016 to treat the previous agreement purportedly dated 26 February as of no effect and void, and would proceed to enter into a new agreement. We have been instructed to first draft agreement to be approved by you and thereafter finalized and executed so that works on the mining area can start. Then there was another letter sent on the 17th by Vandagan, if I may refer. We act for GenX, and we refer to our previous letter on 17th September to you, to which we have not had the courtesy to reply. We also refer to our previous letter to your solicitors Ong Kam Singh, 2nd February, and their reply 5th September, copies of which are both enclosed herewith. We also refer to the numerous complaints our client has brought to your attention, which you have completely ignored. As months have passed without any agreement been achieved between our client and you, you are to proceed with subcontract work on the mining as described as mining Sungai. Our client's position is that you are now sitting on site without lawful authority as a trustee and further obstructing the mining construction. Again, there was no reply until the next letter is 27th, my lord, almost more than about 2 months, from a firm called Arshan, 27th February, October, 2016. They say, we refer to your letter dated 17th October and our client's instruction to reply as to that the reasons our client's not replying your letter dated 27th September 2016 was because they believe that the agreement dated 26 February 2016 is still effective and valid. They have met your clients during the meeting that was held on 19th and 31st, but our clients never agreed to the idea to treat the said agreement as of no effect and void. So this comes saying that the agreement is subsisting about 2 months later. To that, Vandagan replies, my lord, 31st October to Arshan, we refer to your letter dated 27th October, and after referring and conferring with our client, we reply as follows. Paragraph 1 of your said letter is unacceptable as an explanation for failure to reply. It is our client's position that your client did not reply as they knew full well what parties had agreed to and documented. It is an excuse created after discussion with lawyers and an afterthought. Paragraph 2 of your said letter is also therefore refuted as your client did participate in discussion and agreement reached. Paragraph 3 of your said letter is refuted. Paragraph 4 of your said letter is untenable for the reasons stated above and those in our letter of 1710, as well as those in 7.9 to a client to which a significant variance till the current afterthought. My lord, then Vandagan sends another letter, my lord, 31st. Sorry, 29. If I may read. This is addressed to KL Venture, the respondent. We refer to the above question wherein as far back 17/10/2016, you have given 2 weeks to vacate mining area with your personnel and machinery. Please refer to our earlier notice dated 17 October. You had refused to do so and abandoned some of your requirement and plant on the mining land, which obstructs our client's activity. Having since successfully obtained renewal of ML and the latest OMS on behalf of the owner, our client is taking steps to proceed with its mining activity in accordance with the law. Again, no reply. Then Vandagan sends another letter. This time, a new firm of solicitors come on record for the respondent, Andrew David Wong. They send a letter dated 20th December 2017 to Vandagan. They say, we have been instructed that as far as the first paragraph of your letter dated 9th November is concerned, our client's previous solicitor had responded to your letter dated 17 October. Our client denies having abandoned some of its equipment and plants on the mining land. As far as our client is concerned, no mining activity could be carried since October 2016 because of the dispute between your client and the land mine owner, Bayu Mining. We are instructed by our client that the agreement dated 26 February 2016 between our client and your client is still valid and enforceable, and our client is always able and willing to perform the said agreement at any time, but your client refused to allow our client to enter the mining area. We have been instructed by our client that position in the agreement in 2016 is still valid, and our client is able and willing to perform the said agreement. There's no issue on our client vacating the mining. To which Vendagan replies, my lord, 28th, your letter of 20th February, and apologies for the delay in replying. The solicitor in charge is on annual vacation at the moment. We have obtained client's instruction, however, and reply as follows. We are to treat the contents of your letter dated 29. We are to repeat the contents of our letter dated 29 November 2016. We do not wish to litigate by correspondence, but we state your client abandoned the site and left some equipment and plant. Our client's dispute with Bayu Mining was not the reason or cause of your client's abandonment. The reason and cause were as set out in our earlier letter to your client. Your client, however, instigated Bayu Mining to take alleged dispute between them as financier and backer in Bayu Mining suit with our client, an allegation our client has documentary proof of. There's no valid agreement between our client as stated earlier. Again, Andrew replies, on the 19th of, sorry.
You're taking us through all the evidence as though this is already a substantive appeal. You're taking a lot of time here.
Okay, may I cut short
How can
this?
you focus on the threshold, whether you have satisfied the threshold or not?
Okay, very well,
Don't
my
go
lord.
through every bit and parcel of the evidence as though it's a substantive appeal.
Okay, very well, my lord. What we are saying,
Counsel, 5 minit lagi ya.
Yeah.
Terima kasih.
what we are saying is, my lord, when we are relying on Berjaya Times Square and Section 94 of the Evidence Act. But if I may just refer the test laid out in Berjaya, only when the agreement is not clear, it's ambiguous, we then resort, an objective test will be applied. I've gone through the letters, and also there's notes of evidence to show that the evidence will show the main witness has said in cross-examination that the contract is valid. Of course, again, he also says that the agreement is not valid. So he has contradicted himself. Then there was re-examination. He has stressed.
Mr. Ravi, if I could interject, since you have quoted Terengganu Forest, let me read to you what Terengganu Forest says at paragraph 34. This is what is stated in paragraph 34 of Terengganu Forest. Paragraph 34(6), that leave will not normally be given where it merely involves interpretation of an agreement unless this court is satisfied that it is for the benefit of the trade or industry concerned.
Yeah.
That is the principle that say if you are asking for interpretation of agreement, that leave will not be granted.
I totally agree with my lord on that. What we are saying here is, my lord, is if in Berjaya Times Square, there are 4 guidelines given as to how to interpret an agreement. And also in the case of SPM membrane, which is in our bundle of authorities.
Yeah.
The court will only, if it's clear, it must be given a literal interpretation. If it's not clear, then the court will look at it objectively. My lord, if one were to look at section 94, 94 says you can't resort to other evidence when it's clear. So this is where we want to know how far the ruling in Berjaya and SPM membrane can the parties look at other evidence, because the Court of Appeal has looked at other evidence. We are saying it's clear. The minutes are very clear, but the Court of Appeal have looked at other evidences. But Berjaya says you can, it permits, you can look at it. But 94 says, no, you can't look at it. So we want a ruling from the Apex Court to what extent 94 allows. Because all 94 allows, uses the word may, the court may look at it. So it's permissive. To what extent the court can look at other evidences if there's any contradictions or ambiguity.
All right.
That's the threshold. We believe that we have met the threshold. My lord, with that, I go on to the second issue, question number 4.
You have already passed your 30 minutes, Mr. Ravi.
I'm finishing, my lord. Question number 4.
Okay.
Question number 4 is where can the Court of Appeal order assessment of damages when the party prosecuting the case in the High Court has failed to adduce evidence as to damages?
So that is quite factual, you know. I mean, the law is trapped on that. Is how the court interprets it or applies it to the facts of the case.
My lord, what we are saying is here in this case,
the Court of Appeal has that power, you know, rehearing, and we have Section 69 of the Court of Judicature Act. We hear the case, we rehear the case, and we can make decision.
Yes, the Court of Appeal has got power to rehear. I mean, it allows that.
And the Court of Appeal can make the decision to order for assessment to be made, to return the case to the High Court for assessment to be made, right or not? Yes, the Court of Appeal has that power. That's a tribe, very clear law, right or not?
But if the party has failed to adduce evidence, my lord, with regard to damages, can the Court of Appeal do that? Although it's rehearing.
Is it been sent back to the High Court for assessment?
Yes, it has been.
That's where the evidence going to be adduced.
That's right.
But they didn't do it on the at the trial stage, man.
No, it doesn't matter.
And 2, there was no bifurcation, man. There was no agreement between parties. Look, we will only lead evidence on liability quantum to be assessed at a later stage. There was no agreement or direction by the court. Can they do that? That's a question we are posing, my lord.
All right. Okay.
That's all I have.
Thank you, Mr. Ravi. Thank you. Yes, Dato'.
May it please you, my lord. I'm very indeed grateful to my Lord Justice Abu Bakar for raising this issue at the outset, because we were indeed taken by surprise when there was case management and we were given directions to make our submissions. We actually filed our submissions based on the leave application raised by my learned friend in his notice usul. We filed our submissions accordingly. We were very, very shocked and surprised to receive his submissions completely on new issues. Questions of law, of which, except for the last one, the other 3 were all new issues. We wrote a letter objecting and saying that the notice usul should be, there must be an application to amend the notice usul, and then we must be given the right to reply, and that they cannot arbitrarily on their own at submission level amend the questions of law and take us by surprise. But I think we received a note saying you are allowed to file your submission and the panel will decide. So my lord is perfectly correct, my Lord Justice Abu Bakar, in raising this issue. And whilst my learned friend was submitting, we found the passage which my lord, we are at the federal court stage. You cannot do or make submissions which, because at this level, the federal court, we are duty bound to guide the federal court. And they are also at liberty to make their own research and come up with us. And it would not be right and proper for them to point out to us as senior lawyers our inadequacies. My lord, I refer with respect, I will share screen, my lord. Terengganu is in my bundle of authorities, which is enclosure 27, and I refer to tab 6 of my bundle, where I will share screen Terengganu, and to para 32, which is, I think, answers the issue raised by Justice Abu Bakar.
Yeah, you are right. Paragraph 32.
Thank you, my lord. I read, my lord. And this is the guideline by the Terengganu, which all of us follow, my lord. I would say that an applicant seeking for leave to appeal has a heavy burden after he crosses the threshold. That is, my lord, after your lordships have granted the leave, after he crosses the threshold, his appeal shall be confined to matters, issues, or questions in respect of which leave to appeal is granted. This is required by Rule 47 of the Rules of the Federal Court, Rule 47, bracket 4 of the Rules of the Federal Court, which is, and they quote it, the hearing of the appeal shall be confined to matters, issues, or questions in respect of which leave to appeal has been granted. But in my opinion, the appellate panel, that is the panel hearing the appeal, is not prevented from granting leave to amend the question allowed by the leave panel, or even to add in new questions in order to achieve the ends of justice. The requirement of the applicant to draft a question is merely to assist the court in complying with 108(1)(c) of the Rules of the Federal Court. Where leave to appeal is granted, the court may determine the questions or issues which ought to be heard in the appeal, as well as to enable the leave panel to. Therefore, my lord, it is crystal clear that my learned friend has absolutely no right to, on his own, willy-nilly, to amend questions of law at this stage. Therefore, since he had abandoned the 4 questions of law that he had chosen to put before this court in the notice usul, and had, without the liberty of the court and without leave of this honorable court, applied to amend and change new questions of law, this leave application should be dismissed in limine without even going into the merits. But I did not wish to raise that issue at the beginning because the court had allowed us the right to submit. So I waited for my learned friend to submit so that I could respond. But the Court of Appeal was sharp enough to pick it up, and the Federal Court, beg your pardon, was sharp enough to pick this issue up. And we cannot, my lord.
In fact, Dato' Kamanadhan, nothing in Terengganu Forest says that you can amend your question of law at the submission stage.
Thank you, my lord. Yes. And
of course, you cannot do that. You want to amend, you put up your proper application with proper affidavit. You cannot do it at the submission stage where nobody is allowed or have the opportunity to question your submission.
In fact, my lord,
just too late.
Yeah, too late, my lord. In fact, the proper method would have been to amend the OS and apply for leave from this court to amend the questions of law. Then he can say he's abandoning the earlier questions and substituting it with the fresh questions. But on your own, if you do that, then you are not giving me the right to respond because I will be in a dither. What do I do? Do I address the earlier questions? So what I did in this case, my lord, I answered the earlier questions, and I also, in a reply submission, answered the rest, the subsequent questions. And we were burdened with labor, and for all that, we ought to be compensated with cost, my lord, unnecessarily. And the other point which I wish to raise now, on the issue of Terengganu Forest is the point that Justice Abu Bakar correctly pointed out, which was going to be raised by me in my submission, which is at page 46. I'll share screen, my lord.
34 sub.
Para 34
Sub F.
sub F. That leave will not normally be given where it merely involves interpretation of an agreement unless this court is satisfied that it is for the benefit of the trade or industry concerned. Here, there's this issue of an agreement, which, my lord, I have in fact made it easy for this honorable court by filing a core bundle, which is called the Respondent's Core Bundle. And the agreement, my lord, is at pages 1 to 36. I will quickly share screen the RCB, which is the agreement. Now, I don't think we need to, my lord, because it doesn't fall much to it. But I will share screen item 2 of the which is pages 37 to 38, which is cross-examination of the only witness for the appellant, that is the CEO, Mr. Siva Kumar. And to question number 24. Did you instruct, ada atau tidak kamu mengarahkan peguam kamu untuk memohon kepada mahkamah untuk membatalkan perjanjian itu berdasarkan kamu tidak faham isi kandungan perjanjian? Ada. But he said in evidence that although 1.5 months he gave his lawyers, they never applied to cancel it, nor did they plead non est factum. And this was taken in by the court. Now, my lord, I will show, my lord, the minutes and why the Court of Appeal held that they were merely discussions and not any decision to batal the agreement. My lord will see the first minute will be page 39 of the RCB, which the minutes dated 19th of May. I will highlight, can you make it larger, please? My lord will see. My lord will see item 2. It's called discussion. That's all, my lord. My learned friend did not highlight to this court. He merely highlighted agreement dated 26th February is no longer valid and will be void. But that was the issue that was discussed. And the Court of Appeal and the High Court judge fell into the error that my learned friend has fallen into. And the High Court judge said, hey, there you are. That was agreed already. But that was mere discussion. And this is what the Court of Appeal held. They were merely discussing. Now I take my lord. My lord will see that new agreement needed to be drafted out as soon. And Mr. Siva himself was asked to draft the new agreement. Now we go to the second notice, my lord, minutes. That will be at page 40. That's it. My lord will see again that again it was under discussion. My learned friend in his submission converted discussion to a decision. And the Court of Appeal clearly said that this is discussion.
Yeah, Dato', sorry to interject. Perhaps Dato' may want to just reply to Ravi's submission. Actually, the crux of his application for leave today is that he is asking the court to explain the extent of the principles laid down in Berjaya Times Square.
My lord, just before that, my lord, my learned friend has failed to highlight to this court the findings of the Court of Appeal. And I need to point that out before I touch on his submission. And this will be, my lord, at page 13 of enclosure of 31. His own, where he has put this the Court of Appeal, my lord, found held. In fact, I have put it in my submission, and we can go to my RCB, my lord, at page 42. Page 41. This is what, and the Court of Appeal has reproduced this in its judgment. And I think it is our duty as officers of the court to put before the court the evidence, whether in our favor or against us, and then to submit on it, and not to withhold from submitting. I will refer to page 41. My lord will see page 462, question 462. Now, this is my question to the only witness. Until a new agreement is drafted out, what happens to the original agreement? It is supposed to carry on. Is that so? Must be, isn't it? Because Mr. Lee is supposed to do all the work. Answer, yeah. And now we turn the page, my lord, 465. The question 472. So, according to your evidence now, until a new agreement is derived, the old agreement continuing, that is what you just said now? Yeah. Now we go to 474. So therefore, based on your answer earlier, no, my lord, I will read 473 also. This is a question that they raised, which was to be decided by the judge. Please refer to bundle K, issue defendant untuk dibicarakan. Look at your first question. Adakah perjanjian bertarikh 26/2/2016 tidak sah dan terbatal selepas mesyuarat pada 19/5/2016 dan 31/5/2016 di antara pihak-pihak? That is the question posed by you. Betul? Yeah. Now the next question. So therefore, based on your answer earlier, that the old agreement is still continuing until the new agreement has been formed, this answer must be in a negative. The answer must be no. Ianya tidak terbatal selepas mesyuarat sebab you have already admitted that the agreement is still pending. Yeah. Therefore, my lord, the minutes have no more validity at all. And this is what the Court of Appeal highlighted and quoted in its judgment. And my learned friend in his submission, unfortunately, did not reply to that. He did not point this out to the court and say, well, my lord, I have an appeal task here. There is an admission by my client, and I have to overcome that. No, he glossed over it by merely touching only on the two minutes. And therefore, my lord, based on this, the Court of Appeal held that we don't need to go into the law. There's no law here, merely factual. On facts, the man admitted it is still continuing, but the defendant was forced, the respondent here was forced to file a suit because they took out a writ against the owners of the lessee, Bayou Mining, and took out an injunction. And by that injunction, they prevented my clients who are given the right to go into the 99 acres to mine. So they were stopped by the injunction. And the learned judge made a finding of that fact in his judgment, that they were stopped. Having made that finding, he then says my clients abandoned the area. And we have answered all this in our submission. How can they abandon when they were forced not to go in by the injunction? And then they sent in a contractor to demolish all the palong that my client built. It's all demolished and gone. And then they say, oh, no assessment was done. My lord, I'll point, my lord, to a clause in the contract which says that all the palong and the value of the machinery in that site is valued between 1.5 to 2 million. And in our submission, we raised that clause and said, give us therefore 1.75 million. They never submitted at all. We submitted in our submission. But the learned judge said, no, go back and assess it. That's what the Court of Appeal said. We are bound by that. So what is the complaint there? Thank you, my lords. And then the last point, which my lord asked us to reply on the Berjaya Times Square. My lord, I have replied this exactly in my submission, and I will do no better than to just read that paragraph. Enclosure 36, my lord. I will share screen, my lord. Roman X. The applicant relied on the ruling of the federal court in Berjaya Times Square that in interpreting the contract, the court must apply the objective approach, see held 8 and para 42 of the said judgment. It is therefore axiomatic that in applying the objective approach to the facts of our case, the learned High Court judge erred in failing to consider the fact that both parties were in ad idem to the fact that the agreement shall continue until a new agreement is signed. All other issues raised by the applicant are irrelevant to the objective approach relied on by the applicant itself. And the Court of Appeal was correct when it held at para 36. We hence find the respondent admitted or conceded to the fact that the agreement still subsisted consequential to the meetings unless and until replaced by the new agreement. However, the respondent neither retracted nor clarified on the admission or concession. There was an attempt instead by the respondent to portray that the agreement was not understood and ought therefore to be cancelled. We are not convinced and find that it is irrelevant, particularly because the defense of non-est factum has never been pleaded by the respondent. And my lord, there is no re-examination by my learned friend on this issue. This is raised by me, my lord, at page 8 of my submission. At page 8 of my enclosure 36, page 8, Roman 4. That's it. The fact is that the applicant's own witness SD1 admitted under cross-examination that the agreement subsists until the new agreement is drafted, and there was no re-examination on this issue by solicitors. Re-examination SD1 from pages 606 to 615 of Exhibit SG4.
So therefore,
SD1 was not even asked to explain in re-examination if he understood what he meant when he said that the terms of the agreement would continue until the new agreement was drawn up by solicitors. And in the absence of any attempt to re-examine on this issue, the applicant is deemed to have been satisfied with his answer, and no further issue can arise to dispute this. Therefore, my lord, this application for leave is a non-starter from the beginning. First of all, he abandoned his chosen questions,
which was in a proper application.
Which was in a proper application.
Then
he never applied to amend it formally, but
changed.
chose on his own to amend it like as if he has the authority to do so, and that's so in his submission.
All right.
So therefore, my lord, that this application is a frivolous and ought to be dismissed with cause, my lord.
Thank you. Yes, Mr. Ravi, shall reply, please. if any?
Please,
Whether we can amend the leave questions. I again refer to the paragraph read by my learned friend and Justice Abu Bakar, paragraph of the Terengganu Forest case now. If I may share screen. If I may read, I would say that an applicant seeking for leave to appeal has a heavy burden. After he crosses the threshold, his appeal shall be confined to matters, issues, or questions in respect of which leave is granted. This is required by Rule 47 of the Rules of Federal Court. The hearing of the appeal shall be confined to matters, issues, or questions in respect of which leave to appeal has been granted. But in my opinion, the appellate panel is not prevented from granting leave to amend the question allowed by the leave panel or even add a new question in order to achieve the ends of justice. The requirement of the applicant to draft question is merely to assist the court in complying with Rule 108, my lord. My lord, what we are trying to say is, what more in an appeal proper, the court can amend questions. This is only a leave application, my lord. And we submit that we can amend at this stage.
Right.
Then I go on to the next point, my lord. My learned friend has said that the star witness for the plaintiff, the CEO for that, has contradicted or agreed that the agreement is subsisting, and he has looked at the notes of evidence. May I refer to the notes of evidence, my lord? These are minutes, proceedings on the 24th of September, sorry, 11th of June 2020.
Yeah.
Yeah, question number 480. 4343. I can't see it. Go down. One? Page 168, my lord. The question was 163, dalam bahasa Malaysia. I can't see the question. Di dalam surat ini mengatakan bahawa perjanjian itu masih valid lagi. Jadi kenapa kena tanda tangan satu lagi perjanjian baru? Inilah jawapan yang peguam ini jawab kepada surat kamu ini. Sebab saya dan Mr. Lee sudah membuat perjanjian untuk membuat satu perjanjian baru. Ini kita sudah buat null and void. Dalam minit ini kita sudah sebut bersetuju. Then I go on to question number 352, my lord, page 484. I put it to you, this cross-examination, it's a put question. I put it to you, the reason that you did not prepare a separate agreement is because you knew that the first agreement is null and void. That is why you didn't second agreement. Peguam kata kamu tidak buat perjanjian yang lain sebab kamu tahu perjanjian yang ada itu memang sah dan sebab itu kamu tidak buat perjanjian yang kedua. Setuju atau tidak? Tidak setuju. Okay, this is on the 11th of June 2020. Then we come back on the September, 3 months later, almost the same questions were asked to the witness. This is found at page 532, question number 462.
Still not answering the question.
Was the minutes of PDF 213? Okay. Until a new agreement is drafted, what happens to the original agreement? It is supposed to carry on. Is that so? Must be, isn't it? Because Mr. Lee is supposed to do all the work. Sehingga perjanjian itu baru di draft. Adakah perjanjian lama itu diteruskan atau dikekalkan sebab Mr. Lee yang sepatutnya melakukan kerja itu? Jadi sekarang program tanya sehingga lah satu perjanjian baru itu disediakan. Apa jadi dengan perjanjian yang lama? Adakah itu teruskan dikekal? Ya. This is what my learned friend has referred to earlier. But he has failed to show this court the earlier answers, my lord. My lord, may I refer to question number 343?
Yes, sorry, but 343.
Page 482. Three, 4, 3, my lord. It's already referred to. Okay. No? Sorry. Then in re-examination, my lord, because of this contradiction, there was a re-examination. That is found at PDF 289, page 607. Question number 3. Apakah tindakan yang diambil? Tindakan yang kita ambil, kita ada buat perbincangan macam perbualan biasa. Memberitahu kepada VSKL mengatakan agreement yang lama yang kita buat ini tidak sah. So terpaksa kena buat satu agreement yang baru sebab apa perjanjian yang kita buat lama itu tidak betul dengan perjanjian yang kita sign dekat sana. Sebenarnya agreement yang kita buat dengan VSKL ini pada 2015 bulan 10 hari Deepawali ketiga. Saya ingin semua dokumen depan belakang muka surat agreement, tetapi apabila diberi kepada kita pada bulan 2016 cuma ada sign di belakang saja. Yang depan semua satu signatory pun tidak ada. So itu pasal saya minta kita balik satu agreement yang baru dengan Mr. Lee. Saya bagi kontrak ini di atas based on Mr. Lee sebab Mr. Lee saja yang tahu anda buat kontrak macam Johor, dia kena tidak pandai dalam biji besi. So dengan Mr. Lee, bila saya jumpa, memang agreement apa yang kita buat dengan sama yang kita tulis itu tidak betul. So kita akan buat satu agreement yang baru. So I bagi kita akan buat satu agreement yang baru. So I bagi dia satu peluang untuk mendapat satu agreement yang baru. So saya kerja masa dia bagi agreement tapi kita tak beri agreement. So saya cakap dengan dia, kita buat satu agreement baru. Kita akan pass ke dia orang agreement itu. Tetapi dia orang pun macam tidak tunjuk inisiatif untuk mendapat agreement baru dan sambung dengan agreement baru. So dia orang stick on that. So dekat sana saya dapat 2 tempat tahu sudah kena tipu sebab sebenarnya agreement itu dibuat pada 15 tetapi sign 2016. Sebab stamping pun ketiga-tiga kopi itu dia orang pun simpan. Dia tidak bagi kita satu proof sebab itu kita macam tidak ada bukti mengatakan tidak hendak tunjuk dia agreement lama dan agreement baru. My lord, what we are saying is he has explained in re-examination that the first agreement is to be treated null and void in re-examination because there were contradiction in the cross-examination. One moment he says, yes, there's an agreement. Earlier in June, he says, no, we did not agree to that agreement. That's all I got in reply, ma'am.
Thank you. Thank you, Churabi. So we will stand down and come up with our decision. Thank you.
Much obliged, madam.
Much obliged.
Dengan izin Yang Amat Arif, Yang Arif, kes nombor 21 dalam senarai dipanggil semula.
Parties as before, my lords.
Yeah. All right. This is our decision, which is unanimous. We thank Learned Council for their able submissions before us. Having heard the submissions, both oral and written, by both Learned Council and the course papers filed here in respect of enclosure 1, we are of the unanimous view that there is no merit in this application in enclosure 1 so as to justify us to grant leave to appeal against the decision of the Court of Appeal Justices. There is no novel issues or point of law exhibited, and it fails to fulfill the threshold requirement under Section 96A of the CJA 1964. In the upshot, therefore, we dismiss enclosure 1 with cost set at 30,000 ringgit to the respondent, subject to payment of allocated fees. Thank you.
Much obliged, man. Much obliged. Okay.
Kes nombor 27 dalam senarai 08F 22107/2023W. Pemohon Datuk Seri Ashok, anak lelaki PB Krishnan Pillay dan 3 lagi. Responden Datuk Swaminathan, anak lelaki S Mahalingam dan 1 lagi.
Yeah.
May it please you, my lords, Tommy Thomas, together with my learned friends, Alan Gomez, Michael Yap, and Haikaldin Mayudin, we appear for the applicant in enclosure 1, that is for the leave, and my learned friends, Razlan Hadri and Danny Sung, appear for the respondents in the leave application. My lords, we are obliged that this case has been brought forward so that we can report on a development. My lords would be aware that there are 2 applications before the court this morning. Enclosure 1 is the normal leave application, that is ours, and that was followed by a notice of motion to expunge certain statements and exhibits and documents, and that's enclosure 9. Which was filed on behalf of the respondent. What we are seeking, my lord, is that we need the case to be taken up because an affidavit that my learned friend wants to put in, this is in response to our affidavit. The background was that in our second affidavit in the leave application, we introduced what my learned friend says are new facts and new evidence and new documents which were not in the courts below, which is correct because this is they are relevant for leave, were not relevant for matters below the court, in the courts below. But of course, we said, look, they could put in an affidavit. They have not put in an affidavit so far. So what that means, my lord, is that assuming the court is with us and allows the evidence to proceed, then the leave application in enclosure 1 cannot proceed because they want to put in the affidavit. So it makes sense for a better productivity and productive hearing of the matters that the affidavit goes in first. So the arrangement that my learned friend and I have reached is that they will take 2 or 3 weeks to put in the affidavit, by which time all the documents will be ready. And when we return, subject to the court's agreement, and the registrar has suggested that we come back on the 3rd of January next year, which is a date suitable to all counsel and hopefully to my lords. On that day, both applications can proceed, and even, of course, from our point of view, perhaps my learned friend may withdraw enclosure 9, but that's for my learned friend to decide. But if he decides to proceed, we can do both on that day. And the assurance is that on the 3rd of January, if that's the due date that the court gives, both applications can be proceeded with, unlike today. So that's what it's a mouthful, but that's what we want. And perhaps my learned friend can support that.
Yes, okay. Thank you. Yes, yes, Encik Razlan.
Yeah, Ahmad Arif, I confirm what Tan Sri Tommy has informed this honorable panel.
All right. So the third is suitable and convenient for all.
Yes, it is to all council because our diaries were sorted before during the break.
Yes. Okay. Case is adjourned to the 3rd of January 2024. Yeah. To enable exhaustion of affidavit. So parties to appear for enclosure 9 and enclosure 1 to be heard on the 3rd of January 2024 at 9 a.m. All right. Thank you.
Thank you, Ahmad Arif.
And is it also by Zoom, my lord? Just last question is by Zoom.
Yes, by Zoom.
Thank you very much, my lords.
Thank you. Much obliged, my lords.
Kes dipanggil bersama nombor 24, 25 dan 26. Permohonan kebenaran merayu nombor 24 dalam senarai 08F 206-06-2023W, nombor 25 dalam senarai 08I 20706-2023W dan nombor 26 dalam senarai 08F 20806-2023W. Pemohon Tian Tin dan responden Cipta Holding Senjam Berhad dan 3 lagi.
Dengan izin Yang Ahmad, Yang Arif. My name is KFE for the applicants in this pre-notice of motions 206, 207, 208. Allow me to introduce my learned friends appearing for the first respondent in notice also 206 and 207 is Mr. Derek Chan on behalf of Cipta Holdings.
That is so, my lord.
Cipta Holdings is a nominee respondents, Yang Arif. And then my learned friend for the second respondents, Mr. David Matthew, and together with him with Miss Tina Francis, they appear for NU 206, 207, and 208.
For the second respondent in all three, my lords.
Yes.
And then my learned friend for the third respondents for NU 206 and also 207 is Datuk Prince Ramachandran and Shabin Raj.
That's all.
Yeah.
And then my learned friend for fourth respondents in NU 206 and 207, my learned friends Miss R. Vasanti and Habinda Sindhu.
That is so, my lords.
Yes.
Yeah, even though today is fixed for hearing of three notice also, but actually we can just proceed with the hearing of NU 206 because the question of law for all three are the same. If Yang Arif allowed NU 206, naturally the leave will be granted for 207, 208. Likewise, if Yang Arif disallowed leave for NU 206, the other two we don't even need to proceed further. So, Yang Arif, allow me to share screen very quickly just to introduce the background very quickly. I don't wish to waste Yang Arif time on this. Very quickly on the background, and then I'll go to the law. If Yang Arif can see on the screen, this is the submissions enclosure 92. This is just a background facts, all right? Paragraph 2 of the submissions. The present proceedings is relating to the court appeal decisions dismissing the applicant appeal against the decision of High Court delivered on 21st March 2022. It's not 2023, that's a typo error. The High Court allowed the winding up petition by the second respondents here. I will call him Mr. Ter Cheng Hing, all right, in the winding up petitions. And then in the winding up petitions, my clients, all right, Ter Tiam Ting filed a notice of applications in enclosure 60 to ask for a court convey EGMs, all right, in the very same winding up petitions. And then beside the two, my clients has also filed a fortunate injunctions, all right, to restrain the winding up petitions in suit WA24 NCC 387092021. So there were three decisions, therefore there were three appeal to the court appeal, and therefore there are three leave application to this federal court. But for the purpose of today hearings, I would proceed with NU 206 one notice also is enough. All right, very, very quickly, the background facts. Cipta is the first respondent here. It's a nominee company. All right, it's an investment company which is to be governed and bound by the Memorandum and Article of Associations. I would like to stress here, it was not a quasi-partnership. It was a private limited from day one of our formations. All right. And then my clients, the applicant here, and the late father, Ter Yu Chai, alias Ter Swee Long, are the two individuals that have been managing the affair of Cipta until passed away on 11 February 2020. Before the late father, Ter Yu Chai, Ter Swee Long, passed away on 11 February 2020, the shareholder of the Cipta is Ter Cheng Heng, 10%, Ter Wei Hong, 20%, Liu Hua, 6%, Ter Yu Chai, alias Ter Swee Long, who passed away, 54%, this is the father, Ter Tiam Ting, 10%. And then the directors were Ter Cheng Heng, Liu Hua, Ter Yu Chai, Ter Tiam Ting. So even though Ter Cheng Heng and Liu Hua were the directors, is not disputed. Ter Cheng Heng, Liu Hua, and Ter Wei Hong, the other factions of the shareholders and directors, all right, they were never involved in the affair of the Ciptas. All right, they just signed documents only. It's not disputed. All right. Okay, the reason why they are not involved, that is because Ter Cheng Heng, he has his own company to run. There's a company called Capital Group. Likewise, Ter Wei Hong he was not involved because he also is running another company called Checkers Hypermarket Sdn Bhd. And then Liu Hua was not involved because he's a foreigner from China. Okay. On the 6th of November 2021, the applicant late father, Ter Yu Chai, Ter Swee Long, allotted 30% of his share in Cipta to the applicant before he passed away on 11th of February 2020. All right. So
I'm so sorry to interject. James, I think your date is wrong. He died in 2019.
Sorry. 2019.
Sorry, the transfer was 2019.
2019. Sorry. Much obliged. So this I just pause here for a while. I just want to share screen the auditor report of the Cipta to show that this is ongoing concerned company. Healthy financial cash flow, well-to-do company. This is the last auditor report of Cipta, the nominee company, which has been ordered to be wound up. The last one was dated 30th June 2020. The point I'm just trying to highlight is the ongoing concerns. They have a total assets of 22 million, all right, which consists of the property, 15 million, and then they have other property, 900,000, and also other property, 2 million, all right. So total about 22 million. And then they have a retained earning over the years of 30 million, all right. And then the liability is only about a mere 7 million. So there is a net asset of more than 10 million. And then if you look at the revenue, for 2020, revenue is 260 million a year. Gross profit is 70 million. So the point I'm trying to illustrate is this is ongoing concern, which has been ordered to be wound up by the High Court judge and endorsed by the Court of Appeal. Coming back to my submissions, all right. Just to a bit of background, the late father, he had 4 unions, 4 families, all right. These are the family trees. Of course, this is the first children from the first wife. Ter Cheng Heng is the second respondent in this suit. And then, of course, my client is Ter Tiam Ting. His mother is his second wife, Chang Yim Moi, together with his younger brother. And then this is the third union. Ter Wei Hong is the third respondent from the third relationship. And then Liu Hua is the fourth respondent from the fourth relationship. Just to sidetrack a bit, just a bit of family background. So coming back to our submissions, after the late father, Ter Yu Chai, Ter Swee Long, passed away on 11th of February 2020, the shareholding of Cipta has been changed. the late father was holding 54%.
Yeah, sorry, Kanko. So what actually is your question of law?
Okay, Yang
Show
Rif,
us
the
the
question of law.
Yeah.
The first question of law is that whether the principle of fortuna injunctions in the case of Fortuna Holding and Deputy Federal Commissioner ought to be adopted by the Malaysian court. This has not been decided by the federal court in Malaysia before. All right. So I will go to the novelty of a question of law if Yang Rif allow me to finish the brief introduction of the facts. Yang Rif, I go to the.
You can skip the fact. We have read that submission, especially on the factual background. You go direct to the question of law.
Okay. All right.
The question
all right.
And then impress upon us, convince us.
All right. Okay. I go to the question of law, Yang Rif.
Yeah.
In my submissions.
Yes.
Okay. Okay. This question number one. Okay. The first questions whether principle of fortuna injunctions ought to be granted, ought to be adopted by the Malaysian court. And then I just like to have a sidetrack a bit. Probably Yang Rif could also consider this a question I've just raised. Roman 2, whether the petition under legal obligation to give a notice of demand before the filing of Wanyap petitions under section 465 sub 1H Companies Act 2016. This is a novelty of question of law is because when the petitioner filed the Wanyap petitions under section 465 on the ground of just and equitable, they did not give any notice. As we all know that when we file a Wanyap notice, all right, we always give a 21 Wanyap notice. But in this case, it was not given. So we'd like to, Yang Rif, to consider whether the fortuna injunction ought to be granted in this kind of, ought to be considered. All right. Okay. And number two, the question of the
I'm very sorry to interject, my lords, my lady, but sorry, my lords, but I don't see how this thing about notice features in any of the questions posed by my learned friend, unless he's trying to amend it now.
We hear him first, and then you have the right to reply. All right. Thank you.
Yang Rif, is not disputed that the Wanyap petition was filed without any notice. It's not disputed. Okay. And then the Australia case of fortuna injunction was considered by our court of appeal, Mobicom. It merely laid down the case law. All right. I'd like to emphasize here the second branch of the fortuna injunction is that the second branch applies in cases where a petitioner proposing to present a petition has chosen to assert a disputed claim by a procedure which might produce irreparable damage to the company rather than by a suitable alternative procedures. So coming back to our facts here, the petitioner, they have another alternative route. They can file a derivative actions instead of taking a drastic actions to wind up an ongoing concerned company. That is the novelty of question of law raised in the fortuna injunctions ought to be considered by our federal court. All right. And then coming back to the High Court, the High Court, it says that there's no status quo to preserve and no irreparable harm for the application of a fortuna injunction because the advertisements has already been done and the gazette has already been done. By the time our fortuna injunction was fixed for hearing, gazetted, advertisement has been done. So this is a thing that we would like Yang Rif to consider the novelty of question of law.
Right.
Question 2. The second question is, when my clients, the directors, to convey a meeting under section 311, 312, for 2 times, can the directors refuse to do so? in our present case, the directors, they took over the board of directors, 3 directors versus 1 directors. Despite my clients is the majority shareholders. In the absence of the father passed away, my client is a single largest shareholder, majority shareholder. But in the board of directors, he is alone versus 3 directors. So he asked for a EGM to be conducted by the directors under section 311 and 312, but it was refused. So there's no case law on point by the federal court. Would like Yang Rif to consider this. So instead of the directors calling for the EGM, they straight away, they know very well, they will be voted outnumbered. They are only minority shareholder. They straight away file wind-up petitions to wind up ongoing concerns. They ignore section 311 and 312 of the Companies Act, which is mandatory for the board of directors to conduct a EGM. It is mandatory. Allow me to share the screens. Sub 3, 311 sub 3. The director shall call for a meeting of members once the company has received the requisition to do so from members representing at least 10% of the payout capital of the company, carrying the right of voting at meetings of the members of the company. So they refuse. 312 also say the directors shall call for the meetings within 14 days from the date of the requisitions. All right. And 313, if directors refuse to call, the members, they themselves can call 313.
So the,
These are
director
the nominee
so the director can refuse to call for a meeting or not. In that situation, then the shareholders can call the meeting themselves.
Yes, that is what we
the law is very clear. The law is very clear on that.
Yes, Yang Rif, Yang Rif, that is what we did. We did file a notice at the under 313 to call for the EGM, but immediately after we call a notice for EGM, the petitioner filed wind-up petitions without notice, without giving us a 21 wind-up notice, and the injunctions.
That's a different question already. The second
and the High Court
is very clear. The second question is very clear. Okay, you can ask the director to convene a meeting, the request. But if the director fails, the law says that you yourself can convene. Okay.
So that's why there's questions of 311, 312, and 313. That's a question of law here. So because the factual background, and the High Court judge granted injunction to restrain us from proceeding with the EGM, even under section 313. So that is a question of law, Yang Rif. So coming back to my submissions, question of law. So section 313 here, Yang Rif, that's why before my client can even call for a meeting under 313, the High Court judge granted injunctions. And after that, the High Court judge issued a wind-up order. So of course, we have a series of cases at the High Court, Chong Ming Lee, to say that all these are, that it is mandatory that the board of directors, they must convey a EGM. It is mandatory. The directors do not have discretions not to call for EGM under the case of Chong Ming Lee versus APFT, High Court level. And also this case of Cha Noodle by Justice Lisa Chan. In this judgment say very clear, it's mandatory. The board of director cannot refuse. And also this case, Dato' San Leong Kong and Menang by Justice Wan Muhammad Amin, also very clear, is mandatory. Director must call. It's mandatory. So right now we have this question of law, Yang Rif. And furthermore, just to highlight, if they do not call for if the board of directors do not call for the meeting, is an offense under section 588 sub 1B of the Companies Act. It's a criminal offense for not doing so. So this is a question of law we'd like to canvass.
All right, next question.
I go to the next questions. Okay, question C. Subsequent to receiving a requisition from members of company to convey a meeting of the members of a company under Section 311 and 312 of Companies Act, can the directors refuse to do so and choose to wind up the company instead? Shouldn't Fortuna injunction initiated in the case of Fortuna injunctions to be allowed by the court under this kind of circumstances? So right now, probably I just want to add one more line. How do we reconcile Section 311 to 313 and Section 465 of Companies Act 2016? So right now, we have two scenarios, competing statutory provisions. On one hand, Section 311 to 313 to say that it's mandatory to have a EGM. But then the High Court went on the other edge, under Section 465 of the Companies Act, to allow the company to be wound up on just an equitable ground. So how do we reconcile these two? So this is a novelty of questions which has not been decided before. I would like to Yang Rif to consider this a novelty of question of law.
Okay.
And then we go to question D. In the absence of a deadlock in the board of the directors of a company, can the court order winding up pursuant to Section 465(1)(h)? So it's very obvious there's no deadlock at the board of directors level because the other faction of the directors, three of them, they control the board of directors, 3 versus 1. But the 3 directors they combine, they are only 36% share. They are minority. My clients, 1 director, he's a major shareholder. So can the court order winding up on just an equitable ground since there's no deadlock? Question E, must there be some element of quasi-partnership or deadlock in the management's board of directors before a wind-up could be granted on the ground of just an equitable, having regard to the case of Ibrahimi versus Westbond, generally. As when the directors, they themselves, the other 3 directors, are in control of the board of directors, can they initiate wind-up proceedings on the ground of just an equitable when they were not excluded from the management of the company, having regard to the case of Ibrahimi and Westbond Garoli? I will go to this in a short while, the case law, very briefly, all right, on the case law of Ibrahimi. And G, in the absence of a written agreement to participate in the management of your company, there's no expectation to participate in the management of, should the company be governed by the memorandum and article of associations, having regard to the case of Eng Man Heng. So all these questions from C, D, E, F, G, I will lump it together, and then I will refer to I will canvass the relevant question of law.
Yeah.
Obviously, there's no deadlock factually, it's not disputed. So in this case of Charles Forte, English Court of Appeal suggests that there's no deadlock. And therefore, all right, there is another so the Court of Appeal in this Charles Forte English Court of Appeal say that the defendant assert that the directors of the plaintiff do not exercise their power to refuse to pass a transfer in good faith and in what they consider rightly or wrongly to be the best interest of the company. He suggests that they were actuated by the spite against him because he had successfully asserted his ownership of 10,000 shares and had refused to sell them to Charles Forte at his price. Now, if the defendant wish to make up that case, the proper course for him to take, as I see it, is to bring an action in the Chancery Division asking for a declaration to the effect and consequential relief by way of rectification of the register, and possibly alternatively by way of damage in the event of a sales of a share having gone off. But in the circumstances of this case, a petition to wind up a company is not, in my judgment, a form of relief which the defendant can properly invoke. So, meaning to say, I would like the court to consider the case law novelty of point in our scenario here. On one hand, we have mandatory provisions 313 to 313, 311 to 313 Companies Act. Make it mandatory, board of directors must call for EGM. On the other hand, even though the petitioners, they have alternative remedies, they can file a derivative actions if they don't agree. All right. Instead of filing the derivative action, they file a petition under just an equitable ground. So how do we reconcile these two competing legal principles? So I humbly seek leave from this court to allow us to argue further in a full-blown appeal later on. And then the High Court said that if we allow the Fortuna injunctions, that would be allowing us to change the composition of the board of directors and company, and is an abuse of process. So in law, as we know, isn't it that the shareholders in a public listed company or be it in Sdn Bhd, they can change the board of directors anytime they like, as long as they follow M&A, as long as they follow procedures? Isn't that the right of any shareholders, especially the right of a major shareholder? So if a major shareholder want to pass a resolution to change the board of directors, isn't that is his right, fundamental rights? How can that be abuse of court process? So in light of this line of question of leave questions, there's this Australian case of Morgan versus 45 Flyers Avenue, Supreme Court of New South Wales. The facts in that case, in our case, is quite similar. It is quite similar. So, on one hand, there's a one-year petitions to wind up on just an equitable ground. On the other hand, there is a call to have a resolutions to have an EGM to change the board of directors. And then the Supreme Court in New South Wales didn't allow the one-year petitions, because it's an extreme step to wind up a successful and prosperous company, and a strong case must be made up before such an order will be made. And I like to quote this passage. It is, of course, clearly to the case such as Yuan D. Tobacco and Ibrahimi versus Westbourne provide strong authority in this area. However, the danger in this area of the law is projecting the principle which were initiated in those cases with respect to special types of situations into all cases of privately held companies. The tenor of the two decisions referred to is that even though what is really a partnership has in law taken the form of an incorporated company, and even though the primary obligation which govern the parties are legal obligations arising out of the article and association of the law of companies, there may still be superimposition of equitable obligation between the parties. However, merely because these three elements may exist in a particular case does not mean that the court would draw an inference that they will superimpose equitable obligation on the company law, right, and duties, nor will the court assume that just because that once was the case is for all the time, because it's always competent for parties to alter the relationships. Certainly a person cannot merely refuse to attend meetings of the company and then say that there is a deadlock. So right now, the case in this Australia case and our case is exactly the same. But the additions in that case, they refuse winding up order. And then they say that Ibrahimi is not applicable. So this is a novelty of question of law. I would like this federal court to consider these two competing interests. On one hand, legal obligation to call for EGM. On one hand, to wind up a company equitable ground. How do we reconcile these two legal principles?
So,
and then the High Court, the High Court in order the wind up because it took account the minority shareholder wishes. So the High Court decisions seems to suggest that minority view will prevail over majority, and that cannot be the case, Yang Rif. That cannot be the case. Okay. In the case of Ing Man Hind, I got judgments to say that there's no, in the absence of written management agreements, all right, then the governing will be the M&A of the company and Companies Act. Here, it seems that the High Court judge given the one-year order based on the implied understanding to participate in the managements, and that is wrong, Yang Rif.
Yeah.
Okay, of course, we are guided by this federal court case, recent court case, Tan Kin Hiong, all right, versus Tan Yee Hong. Court case really laid down that winding up remedy is a very drastic remedy, should not be granted unless it's in a very, very extreme case. All right. So we would like to reconcile the case of Ibrahimi with this Court case. And then I will go to the next case. And then very recent developments, Arif. Okay. Now, recently, Cipta, they have a subsidiary called THC Rice Company. Subsidiary. So right now, in the subsidiary of THC Rice, my client is a control of the board of directors from day one. Now, they themselves want to call for the board of directors meetings to call for EGMs, which my client refused to attend. Right now, the situation is reversed. It's in enclosure 85. Enclosure 85. Sorry, Arif, just let me pull up this one very quickly. Very quickly. Can you see on screen enclosure 85, Arif?
Yes. But can you please enlarge the font?
Sorry, it's not enclosure 85, Arif. Enclosure 84, Arif. Sorry, enclosure 84. Sorry, it's not this one.
Hmm?
Seventy-five.
75.
Yes. Okay. Can you see on the screen, Arif? Enclosure 75. Okay. Recently, now, this hinge on a question of law. All right. When a member of the company requires directors to convene in meetings, okay, can director refuse to do so? Right now, the situation is reversed. In a subsidiary level, all right, they call for the EGMs in THC Rice, paragraph 9. And my clients refuse to allow. So, and they filed a suit recently only at the High Court, 20th of September, to ask for a court order for a EGM. When I asked for a court order EGM at the High Court, the Insolvency Court refused and proceeded to wind up. So right now, it's the other way around. Now, my client refused to attend. My client refused to call for EGM, and they filed a suit in the High Court. If the High Court allowed, then there will be inconsistency, which I think these questions of law need to be argued substantively. And then lastly, I go to my case law, Ibrahimi.
Yeah.
Okay, this is with my last one, the case law. Enclosure 90.
Ibrahimi.
Yeah, enclosure 90.
Yeah.
Okay, allow me to go to enclosure 90. Okay. Can Yarif see enclosure 90? This is the respondent's submissions. Okay. The case of Ibrahimi, House of Lords, on the point on the equitable ground. So in petitioning for winding up on the just and equitable ground, a member was not confined to such circumstances as affected him as a shareholder. He was entitled to rely on any circumstances of justice or equity which affected him in his relations with the company or with the other shareholders. Okay, let's go to the next one. In the circumstances, it was apparent that the potential basis for winding up order on just and equitable ground exists after a long association in partnership during which he had an equal share in the management. Okay. So this is the cornerstone of Ibrahimi. So Ibrahimi seems to suggest that there must be a partnership. There must be an equal share in the management. Okay. So right now, we go to the judgments of the Ibrahimi. They have dissected, they have referred to a few cases. So in the judgment, the real starting point is a Scottish decision. They refer to the Scottish decision of Symington versus Symington Quarries. There had been a partnership business carried on by two brothers who decided to transfer it to a private limited company. Each brother was to hold half the share. There was, except for small holding for a third brother, to hold the balance for voting. All right. So because, and then the reasons for the court allowed the winding up because there was a deadlock. So this is the case in Symington and Symington Quarries. There was a deadlock. And then we go to the second case. In England, the leading authority is called appeal in Re Yanishde Tobacco. There's a deadlock. There were two equal directors. This is the considerations to allow a winding up because there's a deadlock. Whether there's a deadlock or not, that has to be considered. And then they refer to the next case, Re Lunder Brothers Limited. The directors were excluded from participation in the management and from directors' remunerations. Here, the winding up was allowed because excluded from management. And then in the next case of Re K9 Meat Supplies, there is a quasi-partnership. And then in the next case of Lewis versus Hayes, there is an exclusion of management. So meaning to say, in this kind of scenario, then only the court would allow a winding up on just equitable grounds. But in our case here, there's no such deadlock, there's no such exclusion of participation of management. And therefore, these are the questions of law which I humbly ask Yang Arif to consider to allow us a full-blown appeal to argue this out. That will be all, Yang Arif, unless there's any question from
Thank you very much. Right. Yeah, we hear reply from the counsel for the respondent.
My lord, if I may, I appear for R2 in all three appeals.
Yeah.
My learned friend for the first respondent in application 206, Mr. Derek Chan, is for the company. And in the courts below, he took a neutral stand.
Yeah.
But he's here to assist the court in case the court wants to know the status of the liquidation at present, if invited by my lords.
Yeah, okay.
If I could just proceed.
Yes.
I will start off by saying this, that our apex court is not caught in a time warp. Ebrahimi was decided over 50 years ago. And the federal court in recent years has had two occasions to write very extensive judgments on just and equitable winding up principles. And I'd just like to highlight this. And this is why I would say that my learned friend's applications are entirely without merit. My lord, could I go to the more recent decision, 2021 decision, the case of Tan Kin Kiong, which my learned friend referred to. It can be found in my bundle of authorities at enclosure 90. And it starts, the citation is Tan Kin Kiong, alien
That's paragraph 42, is it?
42, my lord.
Yeah.
Paragraph 45 makes it very clear that it is always necessarily fact sensitive. The circumstances in which it would be just and equitable, always fact sensitive. And I think, my lord, the para integrated network system, or PINS case as we call it, which is also in my bundle, same bundle at page 140 as well. That's also a federal court case, although not strictly on just and equitable, but they elaborated on the principles. And it says that the categories are never closed. Now, my lords, to deal with these questions, I can do no better than to preface it by putting things in its proper perspective. My learned friend has gone on to various facts. I don't find it necessary to do so, but I'll come to the key finding that led to the winding up, because that underscores everything else. And that key finding can be found in the grounds of judgment of the High Court, and that can be found in Core Bundle 1, which is enclosure 80. If I could invite my lords to page 51, paragraph 46. This is what underscored everything else. After careful, sorry, my lords,
Yeah,
with
you
me?
share it.
Yes, please. Paragraph 46, page 51, enclosure 80.
So this is the judgment of the High Court, huh?
Yes, the judgment of the High Court, affirmed unanimously by the Court of Appeal. There's no judgment by the Court of Appeal, but the minutes, the nota proceeding have been produced, and that can be found at enclosure 82, page 472, 474 to 475, particularly at page 475. Perhaps I could just read that out, what the Court of Appeal said. I'll come to that later. Let me deal with page 51 while I'm there. Sorry. Back to the High Court. After careful consideration of the issues before me, in particular of each of TTT, that would be the applicant, submissions and contentions herein, I do find that the parties are unable to work together based on the alleged differences, amongst them in particular the allegations in the alleged dilutions, i.e. fiduciary suit and the rights issue suit, as well as the numerous civil suits that have been filed against one another, and of which some are still pending, as well as the dispute on the withdrawal of the 7 million by I'll call him 3T from the company. And what his lordship did essentially was to adopt a fault neutral position. And that means, given all these allegations, without having to ascribe particular blame to anyone, can they work together or not? That is the overriding concern. Is there a possibility or prospect, whether the company is solvent or not, whether it should be allowed to continue? And his lordship found no. And that can be found at page 53, paragraph 49. So
the fact that it was alluded to by counsel for the applicant just now, despite the fact that it's quite apparent that this company is a going concern, very healthy in terms of finance, it's in the black. Liability is only 7 million. The annual turnover is about 33 million. Yeah, so that one matter, is it?
No, these are relevant considerations, no doubt. Relevant considerations, but the overall the determining factor is by looking at things holistically and asking, would it be just and equitable in the circumstances? And if I could just go through these two paragraphs very quickly, I'll just summarize it very quickly. Paragraph 49 of the grounds of judgment. This was what was overriding. All that said and done, and based on the facts before me, I hold there's a complete breakdown and a total mistrust and confidence between TCH, TWH, and or LY on the one hand against 3T on the other, which has reached the point of no return and for which it is impossible for the parties to a dispute to continue. And at the last line of that, I agree with TCH that the only way for the shareholders to realize fair value for their shares is through a liquidation exercise. Paragraph 50 talks about that the company can no longer go on as a going concern. And let me explain why. My learned friend talks about a deadlock. My lord, a deadlock at board level is but one instance. But here what we have, and let me put this in perspective if I may, there was complete absence of any discord or dispute as long as the patriarch was alive. He died in 2020, and within a couple of months,
2019,
he died in 2020, February 2020.
Okay.
Now the shareholders of the company, apart from the patriarch, represented one branch of each union. And there was one branch, namely my friend Dato' Prem's client, who was not represented on the board. He held 20%. My client wanted to be fair to all parties and said, now that the patriarch is no longer here, we have to run this company fairly, transparently, and move to have him appointed as a director so that he could have his voice on behalf of his family. And that is where the problem started. And the applicant then took out proceedings, 256. My lord, the list of cases are contained in the grounds of judgment, paragraphs 27 to 28. He went for an injunction to stop the meeting. He tried to nullify the appointments, having already acquiesced to the appointment. Justice Lisa Chan denied him his injunction, dismissed the claim, struck out the claim inter alia for being in abuse. Now, why did he start all this? It was because attempts were made to ensure corporate governance. Because prior to that, yes, I accept, while the patriarch was alive, they all allowed him to assist his father to run the business. But then they wanted to see what has been happening at subsidiary level, which he has been controlling on his own. And so they wanted to pass resolutions and participate in management. And he tried to block that. And when they kept trying to pass all these corporate governance resolutions, which the learned High Court judge has set out, there's nothing sinister about those things. There was no attempt to remove him from the board or anything. He didn't want to investigate. And as things started to unfold, eventually it turns out that he had committed numerous defalcations and they wanted to hold him accountable for the sake of the companies. He then took up proceedings, suit 400 before Justice Khatija. He didn't succeed there in trying to block maneuvers. She too dismissed, her ladyship too dismissed that action for being inter alia and abuse. He then barges in to try and force a meeting of shareholders to the fourth respondent's house. He barged into a house, purported to pass resolutions. The company secretary refused to acknowledge it because there was no signature saying that she attended the meeting. He then goes to court and tries for the first time to get a court-convened meeting. And the purpose behind it was always because he wanted to have more shareholders so that he could remove and replace these people who were trying to ensure good corporate governance. Justice Ong Chi Kwan heard the originating summons and dismissed it. Crucially, there was no appeal. There was no appeal against Justice Ong's decision. So my learned friend is coming here and rehashing all the very arguments that have already been decided in all those suits. And yet further, when all these things were happening, he then moves again to requisition to achieve his aims by transferring shares to his mother and his wife so that he can then appoint new directors and remove directors so he can create, he will be free from scrutiny. And that is when my client, the second respondent, got fed up. There was no end to this litigation. And by then, evidence had come out that he had caused a misappropriation of 3.7 million ringgit, and he had caused the dilution of the company's shares in its subsidiary from 19%, from 81%, they were diluted to 19%. He was a shareholder and so was the company. And who was the beneficiary? He became the majority shareholder and has been running the show. So when all this was happening, my client got fed up. The family was at loggerheads. He said, there's no way we can continue. And that is why he moved to wind up. And yes, he took an injunction. And at an inter partes hearing, Justice Nazrin allowed the injunction, saying you are not going to call this meeting until the petition is disposed of. And all this thing about notice, no prior notice, with the greatest of respect to my learned friend, there is no requirement under the Companies Act. The requirement for notice, the 21-day notice, is where you want to rely on the presumption of insolvency. That is not the ground we are going on. We're going under subparagraph H, just and equitable. So all this thing about notice, all a red herring with the greatest of respect. And if I can move on, it is off the back of all this prior litigation and the vicious allegations against both sides. We went to the High Court and said it's just and equitable, but you don't have to find fault. Now, insofar as my learned friend's contention about the Fortuna injunction, this is what, there was no error on the part of the Court of High Court or Court of Appeal, because they applied Fortuna and Fortuna has been applied, and we do submit that the principles are clear. But ultimately, and this can be found at page 39 of enclosure 80 at subparagraphs 6 and 7, His Lordship found on the facts that they had not proven any, even on a prima facie level, that there would be irreparable damage to the company and that the petition was incapable of success. That is the test in Fortuna, one of the tests. The other test, which was expanded upon by the case, the Court of Appeal decision in Movicom, is covered by this next subparagraph. If I may read from the middle, paragraph 7. Do you have it? Can you share screen? Just one moment, my lords. Fifth line from the top. This court finds that the said rights issue suit and the fiduciary suit are separate and distinct issues, i.e., the rights issue suit is to determine the lawfulness of the rights in issue in THC rights and the dilution of the company's shares to be diluted from 81% to 19%, whilst the fiduciary suit is to recover monies amounting to 3.7 million, which allegedly had been misappropriated as opposed to issues raised in the petition. In other words, His Lordship found that these do not constitute alternative remedies. These are causes of action that belong to the company, whereas here, in a just and equitable, it is shareholders coming and complaining that they cannot continue together and the company should be wound up. But insofar as the company is concerned, the company was free to pursue it. So when my learned friend talks about a derivative action, I really do not know where he's coming from, because at that point, yes, we did control the board, so there's no need to go for derivative action. And as things would have it, by way of disclosure, we have in enclosure 65 updated the court. After the winding up, the company acting by its liquidator has procured a judgment against the applicant for having misappropriated, breached his fiduciary duties, causing the misappropriation of 3.7 million ringgit and ordered recovery against the subsidiary in which he controlled. And in suit 530, after a trial, a full trial, the High Court, Justice Ong Chi Kwan, found oppression on the part of the applicant, his wife, his mother, and cancelled the dilution and has ordered a buyout. That is still in progress. There is an appeal against that decision, but there's no appeal against Justice Ong Chi Kwan's decision in a separate suit concerning the 3.7 million. So, my lords, given all this scenario, all these things that have happened, it was just impossible to continue together. And if I can just very quickly now deal with now that I've put things in its proper perspective, my lord. Question 1, I've already dealt with it. Yeah. Question 2 and 3, my lord. My lord, my learned friend is right. The word shall is used, but it is also circumscribed by the overarching duty of directors contained in section 213. If I may just share that on screen. I think we all know the section. The duty is to act for a proper purpose in the best interest of the company in good faith. So director, and my Lord Justice Karim, Dato Karim mentioned it just now, it is always subject to the discretion, and the directors are bound by section 213. And indeed, section 311, which my learned friend refers to, also talks about that. If I may just share screen, section 311 subsection 5, I believe. That can be found in enclosure 80. At page 11. If I may just read subsection 5, a resolution may be properly moved, not passed. It has to be moved first at a meeting unless the resolution, and they lay down, and we say C and D are applicable, if passed would not be in the best interest of the company. Now, my learned friend has had all the opportunity for Justice Ong Chee Kwan to argue all this. He has not appealed against Justice Ong Chee Kwan's dismissal of his application for a court-convened meeting. And my lord, my learned friend now alludes to a meeting called by the holding company against the subsidiary, an EGM. My lord, with the greatest of respect to my learned friend, that meeting was called for by the liquidator, having assumed office, being appointed by court, and under a duty to get in the assets of the company, he called for a meeting to ensure that the rightful majority shareholder is represented on the board. That is the true perspective of things, my lord. So, my lord, insofar as questions 2 and 3 concern, it is circumscribed by the overriding duty to act in good faith in the best interest of the company for a proper purpose. And my lord, insofar as question 4 is concerned, I've already dealt with it by reference to our 2 federal court decisions. Question 6, my lord, if I may I share screen so it's easier for my lords. Sorry, I was rattling away at knowing that lunchtime is coming up. Question 6. Again, my lord, we have moved on since Ebrahimi. Question 7. Ng Man Hin is a High Court decision and peculiar to its own facts. There, what was being relied upon was an underlying agreement the court found on the facts that it wasn't established. Question 8, my lord. Yes, there was a proposal for their own liquidator. And High Court judge has dealt with this very nicely in his grounds. I don't need to go through it. But at the end of the day, he said there is no credible challenge to the petitioner's nominated. There was no challenge to the qualification, suitability. However, my lord, there are numerous cases, and my lords are all familiar. Here, there's already been a lot of discord and dysfunctionality, because on the one hand, you have the respondents who control the board, but who are always trying to be stopped by the exercise of shareholder powers from doing the right thing. And if you have 2 different liquidators, it can give rise to other problems where they don't get along. The federal court case, Shen Court, is a classic example of the discord between when the court appoints joint liquidators sometimes. So his lordship exercises his discretion. Unless you can show me that who is being suggested is unsuitable, there should be an overriding principle that the petitioner's choice should prevail. And especially, my lord, when there are serious allegations of misconduct, breach of duties, financial improprieties on the part of the applicant, should the court appoint his nominee, my lord? I say no. And I say that there's no question here, because ultimately it's a question of discretion depending on the qualifications, suitability, and the circumstances in which they present themselves, my lord. So again, my lord, none of these questions pass the threshold under Section 96. And with the greatest of respect, the entire application is just another backdoor attempt to have another bite of the cherry, to impugn findings that have already been made by no less than 4 different judges in 6 concluded suits, my lord. My lord, the litigation between the shareholders have to come to an end, my lord. And with that, my lord, I humbly submit that in applications 206, 207, 208 do not meet the threshold and ought to be dismissed with cause, my lord. With that, I am very much obliged to my lords.
Thank you. Thank you, Mr. Matthew. Right. Yeah, we hear a reply from counsel for the applicant. A short reply.
My lord, excuse me, my lord. Is my lord going to take each appeal, because everything is more or less connected, and if together, maybe your lordship, I won't take more than 3 minutes, and then the applicant can reply to all.
Okay, all right. Yes.
Yeah, I just wanted to say, my lord, that my learned friend has covered almost everything in my written submissions. I've only got one useful thing to add. The winding up of this company was on 21st of March 2022. Liquidators were appointed. He didn't challenge the appointment, or he didn't stay the appointment, and he never applied to stay the winding up process. Now, what he thinks he's going to achieve by getting leave here, I'm not quite sure, because the winding up process has been ongoing for almost 21st March 2022. We're at the end of 2023. If at all he wanted to really challenge the winding up of this company, what he should have done was to stay the process. Now that ship has come and is long gone. So what I'm trying to say is that, of course, I don't see any of the questions being relevant. I see that the threshold has not been met.
Yeah.
But even then, over and above that, the appeal has got no chance of success. That's all I want to say.
Yeah.
I think my learned friend has, I can do no better than put the case across than David Matthews has, and I adapt what he has said, and I refer to my written submissions.
Thank you.
My lord, just 1 minute. I will also be just adopting what my learned friends, Dato' David Matthews and David Matthews and Dato' Prem have submitted, and rely on my submissions just to say that there are no questions which satisfy the threshold of the federal court. Thank you, my lord.
Thank you.
My lord, for the first respondent, as rightly pointed out by my learned friend from the applicant, the first respondent is merely a nominal defendant. However, my learned friend for the applicant has referred to my client's suit at the High Court to draw parallel towards his leave application. I'm ready to submit on it, but I do not propose to do so unless invited by your lordships.
Yeah, I think that won't be necessary. Thank you.
Much obliged.
Very quickly, Yang Rif. So right now, question of law is which requires federal court to deliberate this, notwithstanding that both parties, they cannot work together because there are various suits here and there, pursuant to different cause of actions. All right. The fact of the matter is, just because there is a various suit between both parties, that doesn't mean as a majority shareholders cannot move the company to have an EGM. That is already provided so in section 311 to 313 of Companies Act. And there are cases which I already say is mandatory. So my learned friend, Mr. David Matthews, to say that the board of directors got the discretions to disallow to have an EGM because of on the purported good faith not to have EGM, that I disagree, and that is to be deliberated in the full-blown substantive appeal hearings. So whether the board of directors got the discretion or not under section 311, 312, 313, we need a full-blown hearing to argue on that. And then the second issue of whether each family, there are 4 unions, each family will have a representative at the board of directors. Yang Rif, that is never the case. All right, in the cost, because it's not a quasi partnership, there's no written undertaking to participate in the management. There's no such undertaking, participate. So, in such scenario, M&A and Companies Act would apply. So, Yarif, regarding the accounting inspections by Justice Khatijah, right? In fact, in the suit, in the accounting inspection suit, Khatijah, we voluntarily offered the account to them in the affidavit. We did not oppose. We voluntarily offered to them. The reasons there was a dispute is because the manner and the venue where to give the account. The account was offered to be inspected at the lawyer office, and they disagreed, and that is where the fight. And then subsequently, they have a commotion, both family, they have a commotion at the office. So, about the misappropriation of fund of 3.7 million and so on and so forth, that is a concluded suit, it's a separate matter altogether. We accept the finding of the court, we respect the finding of the court. My clients in the process of returning the money. Having said that, there is no police report against my clients. There's no criminal misappropriation of funds. That's because my client was contending that the 3.7 million was from the late father estate. It's not from the company. Whatever it is, there's a finding by Justice Song Chi Kwang. We respect the decisions, and we do not want to further prolong the suit. So, at the end of the day, if at all, they find that there's a cause of actions against my client, or we have a cause of action against the client, both parties are free to file suits. Just because both parties, they have numerous suits, that could not be a ground for complete breakdown of mistrust or communication between both parties. If that is the case, tomorrow, in all the public listed company, or all the shareholder in all the Sdn Bhd, the minority shareholder, they just file multiple suits. They will just file multiple suit, all right, on this cause of action, on that cause of action, on alleged breakdown, and then finally file a winding up on a just and equitable ground, and as a justification that the company should be wind up because there's a complete breakdown. That cannot be the case. This is a precedent. Despite there are multiple suits between both parties, we respect the cause of actions of each suit. Likewise, my client must be given the right to call for EGF under Section 311. And then, Yarif, oppression suit. Likewise, in the Chipta here, we have ongoing concerns. The company is doing very well. 223 million revenues, 17 million retained profits. If they feel that they have been oppressed, they feel free, they can file a minority suit. They can compel my clients to buy their share if they feel that they have been oppressed. Instead of going wind up the company, that is too drastic actions. There's an ongoing concerns. Yarif, of course, I'm replying to my learned friend Dr. Pranch, the submissions, there's no stay. Yarif, of course, as you know, to apply for a stay of proceedings, special circumstances is very, very difficult to achieve. All right. If Yarif is minded to grant leave, obviously we will file a stay if Yarif is minded to grant leave. Well, Yarif, that will be all assumption from my side, unless you have any questions.
Thank you very much, Mr. Yee. Thank you. Right. So we will stand down and come up with our decision. Thank you.
Much obliged.
Dengan izin Yang Amat Arif, Yang Arif, kes nombor 24 hingga 26 dalam senarai dipanggil semula untuk keputusan.
Yeah.
Yang Amat Arif, Yang Arif party as before.
Yes. All right. So this is our decision, which is unanimous. But first of all, we'd like to thank all Learned Council for the able submission before us. We have also considered those submissions in light of the cost papers filed herein in support of all the 3 applications for leave to appeal against the decision of the Learned Court of Appeal Justices that had affirmed the decision of the Learned High Court Judge who had allowed the company to be wound up on just and equitable ground, having taken into account all the relevant circumstances as laid before him. In the result, we are of the unanimous view that there is no merit in all the 3 applications for leave to appeal. We find that the submissions in support and forwarded in support of the applications do not fulfill the threshold requirements of Section 96A of the CJA 1964. There is no novel point of law exhibited therefrom, and that would otherwise have justified us to grant the leave that was being sought. In the result, therefore, we will dismiss the leave application, all the 3 filed with cost. We set cost of at 30,000 ringgit in respect of each application to the respondent in respect of each application to the respondent in each of these 3 cases, subject to payment of allocated fees.
Yang Rif,
Thank you.
Just would like to take clarifications, Yang Rif. For NU 206, there are 4 respondents. Are you ordering
No.
cost of 30,000 times 4?
For each application,
So 30,000 to be shared by 4
all
respondents.
in all, there will be 90,000.
90,000.
Yeah.
All in all, 90,000.
Yeah.
So then the 30,000 in each application is to be shared by the respondents equally.
Yes.
My lord, I'm so sorry.
Yeah.
I'm not quite clear. We all represented separately and have different positions. So 30,000 per respondent per application.
No, let's say for each application, we award 30,000. As to how many council, that is not relevant to us. Okay, it's 30,000 for each application.
Thank you very much,
Right.
Yang Rif.
Thank
My
you.
lord, it's just that when coming to do the allocator, because we all separately represented, and
Yeah, I think I suppose that I think you may have to work out.
it will work out, like for example, in application NU 206, it would mean 10,000 for each of us.
Yeah.
My lord, could I very respectfully, and I don't like haggling about cost, my lord, but could I very respectfully ask my lords to consider the amount of work? 3 separate sets of submissions went in on behalf of each party. We all had different positions, and there were different attacks against each one of us. I think separate orders of cost, my lord, would be appropriate, as was done by the Court of Appeal and the High Court, my lord.
Okay, so in the Court of Appeal, how much was awarded?
I received global cost of 40,000 for all.
40.
40, yes.
Yeah, and how about the rest? How about the rest of the respondents?
The other 2 received 15 each.
So this is in which case is this?
For all 3 in the Court of Appeal, cost awarded to R2 was 40,000, global cost of 40,000.
R2?
Yes.
40,000. Okay, how about the others?
15 R3, R4 15.
No, who would have issue on the issue of cost?
Can I be allowed to respond, Yang Rif?
Yeah.
Yang Rif, at the Court of Appeal, it was a full-blown hearings. Took more than half a day. All right. Of course, issue litigated very, very, very detailed. Okay, and then more submissions. Today is only leave applications. Yang Rif, this has been the precedent practice. 30,000 for each application. All right, dismissal, irrespective of the respondents. And L2 and L3, they adopt assumptions. The submissions, no difference. In fact, I was about to ask Yang Arif just to award cost for NU 206 only, because 207 and 208, you don't need to proceed. As I said at the outset, if 206 is allowed, 207, 208 will be allowed automatically. If 206 is disallowed, we don't even need to argue on 207 and 208. So be as it may, Yang Arif, you already make an order. I respect that. Functions officials, 30,000 per applications. So 30,000 to be shared by the respondents in the each application accordingly. And that would work out as far as respondent 2 is concerned. You get more than 40,000 because he appear in, for example, in the NU 208, there are only 2 respondents. He will get 15,000. And then for NU 207, he will get 10,000. And then he'll get another 10,000, 40,000 for leave.
Well, my point was
not even go on the substantive hearing yet.
My lord, my point
I think 30,000 for functions officials, we leave it as is.
My lord, my point was just simply this. Because they are separate firms on record, whatever sum is awarded, we would have to file our own allocator and seek our own costs. And also when it comes to enforcement, if need be, we'd have to do it separately. We can't, 3 firms, file one allocator, my lord.
Okay. Okay. So I think having heard the concern raised by Mr. Matthews in response by KE, I think we will hold on to our order of 30,000 per case, per application, right? So cost at 30,000 as ordered earlier on. Thank you.
Much obliged.
Terima kasih Yang Amat Arif, Yang Arif dan pihak-pihak. Kes selesai.
Right.